viewers. I am Dr. Harpreet Kaur from Army Institute of Law, Mohali. Today we will be discussing the topic of right to live in pollution-free environment, a critical analysis with reference to Article 21. This lecture will help you to understand what is environment and reasons for its degradation, constitutional provisions for protection of environment, right to live in pollution-free environment, and role of judiciary in protection of environment. So let us begin with it. Environment and life are interrelated. The existence of life on earth depends on the harmonious relationship between ecosystem and environment. Especially Homo sapiens have very closely interaction with nature. Human beings are at the center of concern for sustainable development and that they are entitled to a healthy and protective life in harmony with nature. In the long evolution of the human race on this planet, a stage has been reached when through the rapid acceleration of science and technology, we have to acquire the power to transform our environment in countless ways on an unprecedented scale. Humanity's capacity to transform its surrounding, if wisely used and with respect to the ways of nature, can bring to all communities the opportunity to enhance the quality of life. Wrongly or needlessly applied or applied in iniquitous way, the same power can do incalculable harm to human beings and their environment. We see around us growing evidence of human-caused harm in many regions of the earth, the dangerous level of pollution in water, air, earth and living beings, destruction and depletion of irreplaceable life forms and natural resources, major and undesirable disturbances in the earth's climate and protective layer, gross deficiencies harmful to physical, mental and social health in the living and working environment of human, especially in cities and industrial complexes. It is important to recognize our dependence on the Earth's natural resources. Natural resources such as air, water and land are fundamental to all life forms. They are much more than money and economic infrastructure, the base of our survival. Life, livelihood, culture and society are fundamental aspects of human existence. Hence, their maintenance and enhancement is a fundamental human right. Our legal system is working for protection and conservation of our environment. Environment and Indian Constitution. The Constitution of India 1950 did not include any specific provision relating to environment protection or nature conservation. Presumably, the acute environment problem being faced now in the country was not visualized by the framer of our constitution. However, the past 5 decades have witnessed two major developments in this connection. The first development took place when the Constitution 42nd Amendment Act 1976 was adopted in the mid-70s. Specific provision relating to certain aspects of the environment, more especially for protection of forests and wildlife in the country, were incorporated in Part 4, Directive Principle of the State Policy, and List 3, the concurrent list of the 7th Schedule of the Constitution. As a result, the Constitution has now the following provisions specifically relating to environment protection and nature conservation. Part 4, Directive Principle of State Policy, Article 48A, Protection and Improvement and Safeguarding of Forest and Wildlife. The state shall endeavour to protect and improve the environment and to safeguard the forest and wildlife of the country. Part 4A, Fundamental Duties, Article 51A. It shall be duty of every citizen of India to protect and improve the natural environment including forests, lakes, rivers and wildlife and to have compassion for living creature. 7th Schedule, Article 246, List 3, Concurrent List, Item number 17, prevention of cruelty to animals. Item number 17A, forest. Item number 17B, protection of wild animal and birds. Article 21 and right to pollution-free environment. The second major development has been the jurisprudence arising from certain remarkable judicial pronouncements in recent years. More specifically, relating to Article 21 of the Constitution dealing with the right to life. If one is asked which is the most important of all the articles of Indian Constitution, one can only say Article 21, which says no person shall be deprived of his life and liberty, which is the guiding light of India. All other articles are subservient to this. In other words, all articles have been formulated for keeping up this theme song of the Constitution. Life and liberty, no person, not just a citizen, no person in India shall be deprived of life and liberty. It is not included as a mere platitude because over the years, this article, which was a throbbing article, which was the most dynamic of all articles, gathered flesh. And with the help of Article 21, the life and liberty of the individual are protected. Article 21 is the celebratory provision of the Indian Constitution and occupies a unique place as a fundamental right for the people of India. It protects the life and personal liberty. It envisages and aims that no person shall be deprived of his life or personal liberty except to a procedure established by law. Here, right to life include right to health, right to food, right to pollution-free environment, etc. In simple words, Article 21 provides an inbuilt guarantee to a person for right to live with human dignity. Article 21 of the Constitution states, no person shall be deprived of his life or personal liberty except according to the procedure established by law. Article 21 is the heart of all other fundamental rights. Article 21 has very expansive scope and has immense content in two with lesser words. Law is never still, it is ever evolving and ever changing according to meet the challenges of time. Therefore, constitutional provision, especially fundamental rights and in particular Article 21 has been broadly constructed by the judiciary. The court attempted to expand the reach and ambit of Article 21 rather than to accentuate their meaning and content by judicial construction. Thus, the judiciary broadened the concept of life, extended the scope of personal liberty so as to include within itself all the varieties of rights which go to making the personal liberty of men. Basic principles were compiled to understand procedure established by law. The judiciary has resolved most of the environmental cases where they considered right to good environment as fundamental for life and upheld as fundamental right. Thus, we can consider Article 21 as mandate for life-saving environment. This article focuses on some of the landmark cases that have a bearing on the person's right to life and right to pollution-free environment. The constitution makers themselves construct the fundamental rights in its broad sense, especially to right to life. The Supreme Court of India has given a sense to the right so that every person can enjoy life to its fullest extent. The Indian Supreme Court came out of the shackles of mechanical and rule-bound justice and provide impetus to the expanded horizon of the fundamental right to life and personal liberty guaranteed under Article 21. Two methods are used by Supreme Court to strengthen Article 21 and to interpret unenumerated rights under Article 21. It required laws affecting personal liberty to pass the test of Article 14 and 19 of the Constitution, thereby ensuring that the procedure depriving a person of his or her personal liberty be reasonable, fair and just. The court recognized several matriculated rights that were implied by Article 21. It is by this method the Supreme Court interpreted the right to life and personal liberty to include the right to wholesome environment and all other rights. Courts have undertaken to explicate the development of ideology of environment as being part of right to life by various judicial pronouncements. The judicial craftsmanship attempted to expand the reach and ambit of Article 21 rather than accentuate their meaning and content by judicial construction. Thus, the judiciary broadened the concept of life, thus extended the scope of personal liberty so as to include within itself all the varieties of right which goes to make the personal liberty of man. Right to life extended its scope to include right to wholesome environment and right to sustainable development. Indian democracy, wedded to rule of law, aims not only to protect fundamental rights of its citizens but also to establish an egalitarian order. Law, being an instrument of social engineering, obliges the judiciary to carry out the process established by law. Environmental deterioration could eventually endanger life of present and future generations. Therefore, the right to life has been used in a diversified manner in India. It includes inter alia, the right to survive as a species, quality of life, the right to live with dignity, right to good environment, and right to livelihood. In India, these rights have been implicitly recognized as constitutional rights. The right to healthy environment has been incorporated directly or indirectly into the judgments of the court. Thus, it is clear that Article 21 has a multidimensional interpretation. Any arbitrary and fanciful act on the part of any state depriving the life or personal liberty would be against Article 21 of the Indian Constitution. Judicial interpretation to right to life and environment. The right to healthy environment has been incorporated directly or indirectly into the judgment of the court. Link between the environmental quality and right to life was first addressed by a constitutional bench of Supreme Court in case of Charan Lal Sahu case. Interpreted the right to life guaranteed by Article 21 of the Constitution to include the right to wholesome environment. In Subhash Kumar, the court observed that right to life granted by Article 21 includes the right of enjoyment of pollution-free water and air for full enjoyment of life. Through this case, the court recognized the right to a wholesome environment as a part of fundamental right to life. This case also indicated that the municipalities and a large number of other concerned governmental agencies could no longer rest content with their unimplemented measures for the abatement and prevention of pollution. They may be compelled to take positive measures to improve the environment. This was reaffirmed in MC Mehta versus Union of India. The case concerned the deterioration of world environment and the duty of the state government under Article 21 to ensure a better quality of environment. The Supreme Court has held that life, public health and ecology have priority over unemployed and loss of revenue. The Supreme Court ordered the central government to show the steps they have taken to achieve this goal through national policy and to restore the quality of environment. In Subhash Kumar versus State of Bihar, the Supreme Court held that right to life is a fundamental right under Article 21 of the Constitution, and it includes right to enjoyment of pollution-free water and air for full enjoyment of life. If anything endangers or impairs the quality of life in derogation of laws, a citizen has recourse to Article 32 of the Constitution for removing the pollution of water or air which may be detrimental to life. In MC Mehta versus Union of India, the oleum gas leakage case, the Supreme Court established a new concept of managerial liability, absolute and non-delegable, for disaster arising from the storage or use of hazardous material from their factories. The enterprise must ensure that no harm result to anyone, irrespective of the fact that it was negligent or not. In Willoch Citizen Welfare Forum versus Union of India, the Supreme Court held that industries are vital for the country's development, but having regard to pollution caused by them, principle of sustainable development has to be adopted as the balancing concept. Precautionary principle and polluter pay principle has been accepted as a part of law of the country. In Indian Council of Enviro-Legal Action versus Union of India, the following decision in the oleum gas leakage and based on polluter pay principle, the polluting industries were directed to compensate for the harm caused by them to the villagers in the affected areas, especially to the soil and the underground water. enunciating the doctrine of public trust in MC Mehta versus Kamal Nath, the Supreme Court held that resources such as air, sea, water, and forest have such a great importance to the people as a whole that by leasing ecologically fragile land to the motel management, the state government had committed a serious breach of public trust. The changing trajectory of environmental rights in India from a historical perspective, active judicial intervention by NGOs, community groups, and others have also set a series of important precedents that goes beyond what the bare law provide. There are many initiatives in public interest litigation. Some of these include the cases against the construction of the Tehri Dam versus State of UP and Narmada Dam Andolan versus Union of India. The Godavaram Tripura case versus Union of India, a case that has since then spawned dozen orders pertaining against the mining in the Aravallis. Tarun Bhatt versus Union of India against mining in Dehradun Hills. Rural litigation and entitlement Kendra Dehradun versus State of Uttar Pradesh against mining in Adivasi land of Andhra Pradesh. Judgment with important consequences for acquisition or use of land elsewhere on implementation of the Wildlife Act 1972, WWF versus Union of India on implementation of Coastal Regulation Zone measures, Indian Council for Enviro-Legal Action versus Union of India on protection of coastal area against destructive practices. The state of Goa on the right of citizen to inspect official record, the Right to Information Act came into force in case of Goa Foundation versus North Goa Planning and Development Authority against forest logging and other environmental aspects of Andaman and Nicobar Island. The judgment in other cases have set important precedent and direction for further development of policy, law and practice. Some judgments not directly related to environmental cases also have a significant implication for the struggle to establish environment as a human right. Mention should especially be made of number of cases in which the constitutional right to life, Article 21, has been interpreted widely to include a series of basic rights that include environment and livelihood. In Franchises versus Union Territory of Delhi, Justice Bhagwati observed, "We think that right to life includes the right to live with human dignity and all that goes along with it, namely the bare necessaries of life such as adequate nutrition, clothing, shelter over the head and facility for reading, writing and expressing oneself in diverse form, freely moving about and mixing and commingling with fellow human beings." In Shanti Star Builders versus Narayan, the Supreme Court said basic need of man have traditionally been accepted to be three: food, clothing and shelter. The right to life is granted in any civilized society that would take within its sweep the right to food, the right to clothing, the right to decent environment and a reasonable accommodation to live in. So we can say that judiciary is playing active role in the protection of environment. From this lecture, we have learned that such wide interpretation of Article 21 by the Supreme Court have over the years become the bedrock of environmental jurisprudence and have served the cause of protection of India's environment and to a lesser extent of livelihood based on the natural environment. This could be further specified to include right to clean drinking water and to a clean and pollution-free environment. Replacement within the directive principle of state policy of the term forest by the term life-supporting natural ecosystems. The reason for this suggestion is that court and other authorities, including the forest departments, have been interpreting the term forest to mean land with trees. As a result, land without trees is not considered as forest and there is a lack of interest in protecting other important ecosystems such as grassland, deserts, marshes, mangroves, etc. Thus, a chronicle analysis of environmental mission of the court has been undertaken in order to explicate the development of the ideology of environment as being part of the right to life in the Indian context is justified from the above discussion. Therefore, it is evident that Article 21 is mandated for life-saving environment. Thank you and have a nice day.